going, Mike?
Good so far. Getting ready for the holiday weekend, like everybody.
There's a holiday? Aren't you working this weekend?
Well, I still take calls through the weekend, as you know. You do the same.
What is your disclaimer for every long weekend? What's your one disclaimer? I heard you doing it today.
Not really. I mean, I honestly, I take at least 50 calls every weekend.
But you
So,
always have a certain
oh, and
disclaimer.
I'm always concerned about wire fraud on a
Wire
holiday
fraud.
weekend. I mean,
Yeah,
really,
and the point that you always like to make is people have their guard down, and with a 3-day weekend, there's more that could happen when no one's at work. There's no one available to help out in the event of an issue.
yeah, and believe me, the scam artists, they do look for those long weekends.
So we saw a big scam last week, and interestingly, I think this could be really valuable information for those watching. The email addresses that everybody uses, it kind of it led to like some assumptions that the Secret Service and other fraud prevention people that were involved, they made these presumptions based entirely on people's email addresses. So, not that there was anything that the agents or the inspectors or the appraisers did, but they had to fight this wave of guilt, this presumed guilt, because they used an AOL address or because they used a Gmail address or Ymail or Hotmail or all these other mails. So I just want to be on record and tell everybody, if you can, you should really think about moving to a business email, something where it has your brokerage name on it, it has your business, domain or something, because the presumption of guilt is a lot less when there is an event. But if you're using an AOL address or Comcast or some of these other personal email addresses, you tend to be a target. So keep that in mind. It doesn't mean that you are the problem, but it does make your job a lot harder to gain people's trust if the outsiders think that you're the problem. So that's my warning advice. For years, I've been telling people, turn on all your security settings and multi-factor authentication and all this stuff. But now my advice is changing a little bit. I still like all that, but I also want you to realize that there's this presumption of guilt based on what email address you use. So I want to show you guys something really quick before we get into the meat and potatoes. Let's see, screen one. See what I can do here. Mike, can you see my computer screen?
I see. Yeah, I believe so.
All right, you see me on Google here. All right, so let's say you use Google. There is you can go on here, you can create a free account, but what I would recommend is a custom business email. I think it is $5 per month. Pretty sure that's what it costs. And you use all the, let's see where they have pricing in here. So you get started, business name, number of employees, next. So let's say it's just me. Business name is Ross. There we go. Well, it's going to be Ross O, apparently. What's my contact information? I don't want to get too far into it because then I'll get spammed. But I think it's $5 a month, you get all the security settings for a business email. And I know it's extra cost in a market where things are tough to stomach more fees, but it's a wonderful tool to make you look more professional and also kind of fight this presumption of guilt. So that's my soapbox there, Mike. Sorry to distract everybody.
No, good advice.
I'm just kind of, however anyone tries to get better, that's what we're trying to do. We all have to get better, and that's one way we can all get better. All right. So Mike, I kind of prepped you a little bit. We do get, I don't know what the percentage would be. Maybe it's probably less than 10%, but it does happen quite quite enough at least that the seller negotiates with us on the form for the listing agreement. So they say, Mike, we'd love to have you represent us in the sale, send us the agreement, and we send it over. And I'll show you what I saw recently. Here's an example of what they sent over. Now, I blanked out some of the more specific information, but this was a marked up listing agreement that the seller sent over. Now, the first thing we all have to realize is this is okay, right? This does not mean your client doesn't trust you. It does not mean that you're never going to get the deal or that your broker's never going to agree to it. It does mean, however, that your seller is pretty strong. They're intelligent. They have an opinion. Imagine that, Mike, an opinion. Scary. So first things first, you got to put it in front of them. Second thing, they give you feedback. Third thing, let's read it. Let's try and understand it. So before you react, before you do anything about it, you just say, okay, thanks for sending it back. Let me take a look at it. I'll get back to you. And obviously you want this kind of quick. You want to turn on quick because you don't want that seller to get some sort of, other idea and want to hire someone else. So this is a FAR listing agreement, I believe. Yeah, Florida Realtor. So this is a FAR listing agreement. What I want to focus on is not the entire document, but what was questioned. So first things first is price. A lot of times you're going to leave this blank because you really just want to get the form in front of them. So you're going to put everything else and then you're going to discuss what the price will be. So this was a strategy that the listing agent employs to make sure that, all right, we're going to discuss the price. We're not just going to choose my number and we're not just going to choose your number necessarily. We're going to come to a solution because a lot of times the seller may be way too aggressive with their price. Other times they may not be aggressive enough. And that's really where you can show your first value is the research that you did. So I think the strategy of this listing agent is that they leave it blank. First highlight here, broker obligations. Broker agrees to make diligent and continued efforts to sell a property in accordance with this agreement until a sales contract is pending on the property. And you'll see here the comment. Let's see if I can do so here's our comment. The seller's indemnification clause. There's no seller's indemnification clause. How are we protected for negligence, etc.? So I actually looked at this. I thought it was an interesting question. I don't think I've ever gotten that question before, Mike.
No, I haven't either. Going back to that blank thing.
Yeah,
Chris,
sorry.
what happens when someone sends me the listing? They want me to sign it ahead of time and everything's filled out except price. I'm always leery as the broker signing it, when there's something, a really material point that's left blank. It seems to me if they want to get it in the hands of the seller, send it over to them with the price left blank. But yeah, I like being the last signature. That way I can make sure everything is filled out.
Yeah, and so that's something, I think one of the really great things, and I'm glad that you're on this video with me, Mike, is I want people to see what it feels like to be from your perspective, and then separately how it feels like from my perspective. And then the third side of it is, realtors, how you guys feel. And so if you can understand the way we review these documents, it can probably help in how you present them or prepare them. Mike, I get it. Price is a material term, and it's certainly not a valid contract until that is included. Maybe you sign it, maybe you don't. But agents, keep in mind, if you want your broker to just sign right then, don't give them any reason to not sign it. And that would be reason number one, fill out all the blanks.
The problem that I see with price, you're not going to believe this one, but this is not isolated. It happens frequently, is the realtors rushing through to get everything done and they do a typo on the price. There's an extra number. Maybe it's $550,000 and they do 555 or there's a typo.
Yeah, that would be a problem. I don't like that. Yeah, and and at that point, that's where it gets really tough because what I find, Mike, is that the realtors get frustrated when there's a lot of back and forth.
Yeah.
When they keep going back for revisions, they keep going back for revisions, and they feel like they're losing their client. You only have so many shots, you only have so much trust until the client decides you're not worth it. So the back and forth, we got to avoid it. We've got to double check, triple check. Mike, honestly, goes back to what you and I have been saying all morning. We've got to be better. The broker
Well,
has
the
to
other
be
thing
better. The
is
agents have to be better.
they like some sellers, not all, but some sellers like changing a lot of things in there that you originally put out to them. And you got to pick your battles. If you draw your line in the sand, you're not willing to give on any of the points they bring up, then you're probably going to have a problem. So you
Yeah,
have to
absolutely.
determine what's important to the firm, what's important to you, and you got to figure out, okay, if I'm going to give him some of his points, where where are we comfortable giving, so to speak?
Yeah, you're making this determination of business decision and legal decisions. You guys have a lot of autonomy to negotiate these as long as you're okay with it and your broker is okay with that business risk. Separately, what is the law? What is required? What can't we remove? What has to be included? There's this balancing act. So these listing agreements, they're not perfect, and you can't assume they are. It doesn't mean your seller is bad for asking things to be changed, but you might have to bend a little bit if it's not relevant or not hugely important. And we're going to see several of those. In fact, before we even get to number 4 there, I wanted to point out personal property, including appliances, all appliances, bathroom mirrors. I saw an agent make this mistake recently where the listing agreement and the MLS said what wasn't staying or what was excluded, but the sales contract said something completely different. Which one rules? The sales contract. The sales contract rules. However, in that scenario, the seller, even if they're required with the buyer to, not exclude those things or to include them, they're going to turn to their listing agent and say, you should have known better. You knew we had this. That was in our listing agreement, yada, yada, yada. That's the tough one. So just keep in mind that if they're telling you something like that, got to be a good listener. Got to make sure that's in there. All right. So number 4, broker obligations. So Mike, what is a seller's indemnification clause? That is ultimately the question. So this client is saying, where is my seller's indemnification clause? And what that means is where the seller is saying, or the broker is indemnifying the seller against any potential damages that might exist. So they're saying, I will indemnify you, Mr. Seller, in the event that I misstate something in the listing. I say that it is impact windows when it actually is not, and it causes an issue, or that maybe I don't disclose all the condo documents and the buyer can get out of the deal. There are absolutely things that agents can do, that attorneys can do, that could cause damages to a seller or to a buyer. And so this particular seller is asking for indemnification clause saying, the broker will protect the seller in the event we make a mistake. That's kind of brutal. What do you think, Mike?
Just brutal. And
So
then you get into, okay, if depending on what you what words you put in there, does that conflict with your E&O policy?
it could. In the very least, what it does is it raises your level of duty to the seller. You now have more liability in the event you made a mistake. Now, a lot of agents, and really this is the silver lining of our industry, agents think that they owe that duty anyways. So, I've had multiple deals. The impact windows thing is a real thing where the listing agent puts on MLS that it is impact windows. It ends up not being, and the seller has to eat some money or the agent eats some money. I did have a deal where the listing agents paid $30,000 to the buyer from their commissions because they misstated the number of impact windows. So that was a pretty big deal. But without that indemnification clause, maybe they're not obligated. Maybe there wasn't that requirement. But there is a sense of like, do the right thing that's included on there. I do want to skip, because I think it's relevant, this here, and I think this is why the seller brought it up. The seller is indemnifying the broker. So as much as we like to say that that's a brutal, reality of being asked to include that indemnity clause, well, we're protecting ourselves. We've got an indemnity clause on there. So let's read it. Indemnify broker and hold broker harmless from losses, damages, costs, and expenses of any nature, including attorney's fees, and from liability to any person that broker incurs because of 1, seller negligence, representations, misrepresentations, actions, or inactions; 2, the use of a lockbox; 3, the existence of undisclosed material facts about the property; or 4, a court or arbitration decision that broker who was not compensated in connection with a transaction is entitled to compensation from broker. This clause will survive broker's performance in the transfer of title. So we're protecting ourselves as brokers or as real estate agents against the seller lying to us, but there isn't that mutual indemnity from us to the seller. So this one, I don't know exactly how the listing agent resolved that. They may have agreed to do some limited indemnification clause. A lot of times we limit remedies to the commissions that were actually earned, which could, that limits the bleeding. And so reach out to your broker, reach out to your attorney to negotiate things like that. I wouldn't draft language on your own, and I wouldn't just rely on what the seller wrote necessarily. I would have everything reviewed. Have you ever had that, Mike?
Yeah, number 3 to me is the most important, or one of the most important things, because particularly if the seller is not willing to fill out a seller's disclosure statement, you're always concerned about what does he know that I don't know. And yeah, maybe it's something where yeah, there's a problem on the decking in the pool area, and if someone's going to be walking the property and they trip and fall on that problem with the decking that should have been disclosed up front, you want to make sure you're protected.
Yeah. Yeah.
So that's a big, there's certain things I'll give on. The indemnification to the broker is something I take a very hard look at.
Yeah.
'Cause you
So
don't have to take every listing. I mean, really,
you don't have to take every list. That's great advice, Mike. I mean, I think most listings can be salvaged. This doesn't mean it's the end of the road. The advice I gave this listing agent was pretty straightforward. I just talked to him and I said, hey, talk to the seller, see how big of an issue this is for them, and see what one thing they're specifically worried about. What are you most worried about? How can I kind of cover that? We always do the right thing, to the best of our ability. But if, we have to limit our exposure on some of this stuff because we're not entirely in control. The best thing we can do is market your property and present the offers. So I don't know exactly where that one will land, but ultimately, if they agree to do some limited indemnity clause, it's going to be with the broker's blessing always. And if it's not salvageable, then that seller's going to have to hire someone who is willing to do something like that. They are willing to take on that additional risk. So we'll see. We'll see how that one plays out. He also had a question for a transaction broker. So you'll see line 73, he was questioning that. And I think there's a question further down that he wanted to go over. But basically, his question is in regards to confidentiality and whether the listing agent can properly represent him if they're only transactional. So that's a question that, I've answered that one before on these videos. I'm sure we'll be answering it later. But I would always look at what the definition of a transaction broker is. In fact, it's usually not as problematic as many people think. Let's see if I can get the definition of this. So a transaction broker provides a limited form of representation to a buyer, a seller, or both, but does not represent either in a fiduciary duty. Let's see, there's a better definition of that. It's the default agency relationship status for Florida real estate agents. I'm gonna have to find this later, but it doesn't mean you have to tell both sides everything. There is a limited confidentiality included with a transactional nature. So what I recommended in this case was pull the definition from Florida statute and then disclose it to the seller and say, hopefully this answers your questions.
You know, you have actually, there's a great point. Can you go to line 105, Christian?
Yeah.
That
Leaves a
bit in there
faucet on
about,
that floods a room and causes damage.
I've had that more than once. And what happens is someone has power turned off to a property and the water turned off. Someone's walking the property and they're turning on the faucets, find out there's no water coming out. If you're not watching them as you're walking through the property, they could easily turn a faucet on, and when water doesn't come out, they don't turn it back.
Yep.
And then when when the people go under contract and want the water turned on to make sure everything's working, they don't realize that the one faucet's open, there's hair down the drain, it's clogged up, and next thing you know, the house gets flooded. And I've seen that more than once.
I had it once where the inspector turned on the water to, I don't know, maybe one of the sinks. And the reason why it was turned off is that it was leaking. So the inspector turns it on and does their inspection and then never turns it back off or something. And you know, a week went by and the whole place had been destroyed. So to answer this question, his question, how are we protected as sellers from the negligence of a buyer or their broker that damages our home during a showing? And the answer is actually pretty straightforward. That's all stated in the sales contract. So don't get too ahead of yourself. If there's another, you know, buyer that comes and we go under contract and they do a formal inspection, the sales contract would indemnify the seller against things like that. Now, it's not a perfect solution. You know, if someone damages your house, it's still your problem. It may not be your fault. You might be legally protected, but you still have to resolve it. So I always tell sellers, and I told this seller, be proactive. You know, do a search of the house, make sure everything is in working order. If there are any trip hazards or anything that could cause damage to someone just walking through it, you know, make sure that's rectified, or in the very least notify any people who are entering the property. And then separately, the other thing we see, Mike, is theft. It doesn't happen that often, but occasionally you'll get a complaint that, oh, my watch is missing or my jewelry is missing, something like that. And, you know, you have to tell the seller, you have to make sure that they just remove that stuff before they have any sort of showing. That there's just, it's almost like a valet or any sort of car parking area. They put those releases or waivers saying, you know, we're not responsible for the loss of any personal property. So the seller just needs to protect themselves in that scenario.
You know, where you see some theft, believe it or not, is you always think about jewelry, but the medicine cabinet. Believe it
Oh,
or not.
interesting.
I mean, I've seen that multiple times where, you know, drugs all of a sudden are missing, and it's shocking, but unbelievable.
Yeah, unbelievable. All right, next question is on compensation. Surprise, surprise. This one will continue to come up. So closing is not a prerequisite for broker's fee being earned. Mike, off the top of your head, does this come up often? You know, is this something where the seller has to be reminded that the commission's already been earned?
Yeah, it comes up when there's seller's remorse.
Yeah.
And all of a sudden, the seller doesn't want to sell. Maybe his wife and he are not on board in an agreement with each other, and so then he, you know, comes to you. How do I get out of this? Well,
Yeah.
we're not allowed to give legal advice for one. We're not experts on how to get out of a contract, but invariably, the agent will come into me and say, "Wait a minute, you know, I brought a ready, willing, and able buyer, and it went under contract. I didn't do anything wrong. So what about my commission?"
Yeah.
And then you have to have the conversation with the agent on, is this a battle you want to pick? Because the reality is, yeah, if you hold firm and you get that commission, let's say this seller is going to tell everyone in the world about what you did to them. And sometimes you're not willing to risk that kind of hit to your reputation. I don't know. There's always extenuating
There are
circumstances.
always extenuating, I would say 1% of the time, maybe it's a little more, but it's not very much. The listing agent needs this language because the seller's trying to back out of the deal, or they're trying to threaten someone that they're not going to pay, or that they're not doing a good job. I've got a closing right now where the seller doesn't think the agent did a good job. They didn't like the marketing, they didn't like the pictures. Well, guess what? They got a buyer and they went under contract, and the buyer's going to close. So the listing agent deserves to be paid. And just because you're trying to fire them a week before closing doesn't mean you can get out of having to pay the commission. I think this is a very important point that you just discuss with your seller. And a lot of times we don't remove it. But if you decided to, it would be because you trust the seller and you're willing to take that risk. That if something were to go wrong, this is not the seller that you're going to make a big deal about. We're just going to roll with it. If the deal falls apart because the seller defaults, then we'll just, we'll pick up the pieces and we'll do something else. It's very rare that a listing agent has to force their hand, but it is nice to have this when they need it. All right, number 10, broker relationship. This goes to the first question. Are we required to fill out a consent to transition to transaction broker notice if you're acting as the transaction broker? You won't, because that's what they chose above. So up above here in line 73, that they're already acting as the transaction broker. So they won't have to do any sort of notice or transition over. I suppose, this contract was written so that if you chose single agency and you're only representing the seller and then you find a buyer, yes, they would then have to transition over to transaction broker. This is not something that you can remove. You can't take this out of the contract. That just has to be disclosed to a seller in that case. Let's see. Really messing with this this software. It's being weird. Let's see if I can zoom in a little bit more. All right, let's see, limited confidentiality with seller unless waived in writing. Okay, so I found the statute. Let's see if I can share it with you guys. New share. All right, right here, transaction broker. This is directly from Florida statutes. Means a broker who will provide limited representation to a buyer, seller, or both, but does not represent either in fiduciary capacity or as a single agent. In a transaction broker relationship, a buyer seller is not responsible for the acts of a licensee. Additionally, so that would be like accepting notice on behalf of a buyer or seller, or accepting an offer on behalf of a buyer or seller. So this is the more important part. The parties to a real estate transaction are giving up their rights to the undivided loyalty of a licensee. This aspect of limited representations allows a licensee to facilitate real estate transaction by assisting both buyer and seller, but a licensee will not work to represent one party to the detriment of the other party when acting as a transaction broker to both parties. So there is a limited confidentiality. I can't disclose something that a seller told me in confidence just to help out the buyer. That's not allowed. That would be a violation of Florida law. Can't do that. So that just has to be explained to your seller and say, look, this, don't tell me anything that, you're trying to keep completely confidential, but if it is to the detriment of one party or the other, I'm going to have to, we have to follow the law here. Mike, you don't know this number off the top of your head, but I'm going to ask you to do it anyways. Number of agents, percentage-wise, that are transactional brokers in any given year.
I'd say it's above 90%.
I agree with you. It might be 100%, except for a couple of outliers. Pretty much everybody is transaction broker, and it still works. Everyone closes. Let's see what else we got on here. I gotta do my share screen again, so give me 1 second. Perfect. All right. Number 11, conditional termination. At seller's request, broker may agree to conditionally terminate this agreement. If broker agrees to the conditional termination, seller must sign a withdrawal agreement, reimburse broker for all direct expenses incurred in marketing the property. And put in a cancellation fee, they put 0. So if you outlaid money for, maybe pictures, or there was some, other fees that you paid to a marketing agency, you should be able to get those back. You can void a conditional termination. Seller fee, it has to pay your commission anyways. So this is only if you agree to the mutual termination that they would still have to pay for these reimbursements. But that being said, a broker doesn't have to agree to a termination. This is a somewhat voluntary.
I
Mike,
had
does that
this
make
issue this
sense?
morning. I had it this morning, Christian. You know, the number one thing though that pops up that I always have to counsel agents on is that they understand the part about being reimbursed for their hard money they put out, but then they get into, what about all my time I have into this listing? That's a little bit of a different animal.
Yeah, and that's where on line 144, you could put a cancellation fee. They have 0 on this one, and I think a lot of listing agents probably do that. But you could easily put $5,000, $10,000, $1,000. And if they ask you, say, well, I would just be for my time, the back and forth, the marketing, talking, putting this together with my office. These are just above and beyond hard costs. They're more soft costs. And I think that's reasonable. And you just have to do it in a way, you have to explain it in a way that makes sense to everybody. If you can't make sense of it, you're probably not going to be able to charge it. All right, so miscellaneous, number 13, this agreement is binding on seller and broker's heirs. A broker may assign this agreement to another listing office. Mike, have you ever used that? When does that come up?
I don't like that at all, to be honest. I mean, I remember years ago, we had an agent that came over with over 100 listings. And the other broker was willing to assign them. In fact, was almost in a hurry to assign them over to our company. And the blowback is usually the consumer saying, wait a minute, no, I listed with that company. Why am I being forced to? And so it was, I vowed I would never do that again. And at the time, it seemed okay. Everyone, I assumed that the various sellers were fine with it, but some weren't. And that was in my first, I believe, one of my first 2 years in the
Yeah.
business. The
Well, I
school
think
of
you're
hard
right.
knocks.
It comes up when the agent is switching brokers and they want to take their listings with them. And so, number one, I think this could be explained very easily to this particular seller, and I'll explain why. Ultimately, I think later on in these comments, he specified, oh, he says it here, up on the top. He says, strike this sentence, we are contracting with you, not anyone else from another office. So that's, obviously not the case. That is not how these listing agreements work. So that just has to be explained to this buyer or to the seller. I don't mind this language where they can assign the agreement to another listing office, because if a lot of times the relationship is with the agent, and if they switch, they don't want the seller to be able to fight that. Mike, to your point, if that were to happen to you again, once everything gets assigned to your office, you could just let the seller out of all the agreements. You'd be like, all right, well, we'll void it. No worries. We'll just cancel it. But ultimately, I think that language should stay in there so that you don't have to create a whole new listing agreement. Let's say you've got, like you said, 100 listings. You'd have to create 100 new listing agreements if that agent were to switch over and be allowed to take their agreements with them. So it might be better to leave that in there for the seller's sake and our sake, because you don't have to get everything re-signed.
You
Can you
also would
give
have to
more?
look at the seller's disclosure statement. Maybe they filled it out a year ago
Yes.
with that firm and something's changed. So you'd have to
Yeah.
take a look at
The
that.
broker will always want to look at everything anyways, and they might ask the seller, hey, that prior broker never required a seller disclosure, but we do, or whatever it may be. It might need to be updated, but this language could help in the event it was done correctly to begin with. Can you give more context on how your role will change when you bring a buyer to the table? What can I expect? I get this question a lot as an attorney. What's it like when you represent both sides? And my answer is actually pretty simple. Technically, I'm not representing both sides. I'm just handling the transaction. That being said, if you have questions or concerns, if we need to make an offer or negotiate, if you want my opinion, I will give it to you freely. And I do have some limited confidentiality that I have to have with you. It may not be attorney-client privilege, but it will be, you'll ask a legal question and I'll give you a legal answer. As a realtor, you can kind of use that same pitch where you say, actually, I think this is going to work better for you. If I'm on both sides of the deal, we don't have too many cooks in the kitchen. If the buyer has a problem, they call me and then I call you. As opposed to the buyer tells their agent tells me, and then I contact you, and there might be two attorneys in the middle. So I think you just have to role play how you would respond to something like that, and ultimately tell them my representation of you doesn't change. We still need to get to the finish line. We still need to negotiate the best deal for you, and you are still 100% in charge. But my job, I am extra motivated to get your deal closed because it means that much more to me. How you want to kind of pitch that, or whether you're even willing to do it. Mike, I assume there are agents that refuse to do a transaction broker for both sides.
Not a lot, but the other selling point, Christian, is by being a transaction broker, if you have both sides, your communication is better, because how often have you heard the agent say, I can't reach the other agent, they're on vacation or whatever, but if you're it.
Yeah, that's a great point, Mike. So I actually was asked this question yesterday about, two attorneys or one attorney, who, how should it be? And I said, one of the benefits of having just one attorney involved is they can't blame someone else for not being ready. It's like if Peter is on the other deal, Peter can blame me because my office hasn't gotten him something. But if it's only Peter, he can't blame me anymore. He has to just own up to it. But maybe that's the silver lining. The rest of this I wanted to just share with you as just an example, so you can look under the hood of how other agents potentially handle a good listing agreement. They put in here, the broker represents, if the broker represents both buyer and seller, total compensation shall be reduced to a total of 4%. We do see that frequently. Mike, it goes to the other point that you and I love talking about. Commissions are negotiable, right? Commissions are negotiable. And this is an example. This is negotiable. Listing will be live on MLS as soon as photography and videography are both complete. The listing agreements specify how many days you have to get it into the MLS. So I always like to put something in there that says, hey, it may not be available right away, or, upon the completion of the photography and videography, it shall be made available within 72 hours, something like that. Obviously, everyone's, yeah.
If you think about it, Christian, if you have both sides and the commission is lowered 1%, whatever it is, what you're really doing is the seller now is motivated to help you get both sides. He saves money if you get both sides. So it's almost like a win-win.
Potentially, as long as the agent is still working in everyone's best benefit, not just their own.
Right.
If you are ignoring other offers because this one you'd be on both sides, that needs to be disclosed to your clients or to your customers. There's no other way to do it. It would be unethical for them not to know why you prefer this deal over others. Mike, it would probably be terms for losing your license if you didn't share offers from other clients or other agents that were not your own. Huge problem there. So don't ever cross that. Don't blend those lines that badly.
And it'll blow up because someone that didn't get it, they're going to be watching that deal to see.
Yeah, I get comments all the time from agents that call me and say, can you believe what that person did? Of course they didn't take our offer. They had both sides on the other. That's an awful thing to be said about a listing agent, especially if it's true. If it's not true, they shouldn't be saying it, but just that impression is hard to defeat. It's a hard one. You got to give everyone a fair shake. You have to specify, be a good communicator for sure. This is the other strategy that I liked about this listing agent. They include this homeowners association community disclosure, and they actually filled it out with the owner. They did it together. And then when they put it all together, they had it available for the seller to sign with the listing agreement. They also put together this seller disclosure. They didn't answer any of the questions for the seller, but they are going to ask the seller to complete it. And it's just part of the package. Yep, fill this out. If you have questions, call me. You're setting your standards of like, this is normal. We do this on every listing. We have all of this available in advance. I do not want to see this stuff done at the day you get your first offer. I like to see it done in advance. They also had some other disclosures. They had the Hurricane Ian. They had this addendum that I think it was something about the board. I just thought that was really well done. I think if you have a condo association, you should have all the condo docs available when you sign, or at least when you list. I think that's a wonderful tool. Mike, you ready for the next part? And then we'll finish shortly, but let's see if I can pull up the other thing I wanted people to see. See if I can find it. All right, here it is. So I kind of very quickly mentioned this in my email on the invite today, but we are doing a closing and there was a lawsuit filed against the association. So it was referenced by the estoppel letter that we got prior to closing, and it said the association is in litigation. Please ask for more information. So I find it and I look at this issue. This is a community here in Naples. They are being sued by the state of Florida Department of Legal Affairs, Office of the Attorney General. So this is not some homeowner who's upset and hired a lawyer and is making a mockery of the court system. The state of Florida Attorney General is suing the association. So I started to think, all right, this isn't like a slip and fall. This isn't like my association fees are too high. Let's see what it is. Factual allegations. This is all public record, by the way. This person bought a home. She has 3 children under the age of 18. Let's see. She wanted her children to take advantage of the association. This association is not registered with Florida Commission on Human Relations as a 55 and older community and or designated as adult or senior housing. So you don't have any sort of like extra protections against sort of discriminating against age brackets. So let's see. Defendants implemented and enforced restrictive policies directed at children. See if I can put this. Related to the use of common elements. Foxfire did not allow children under 12 years to be unsupervised in any common areas in the community. At all times relevant, she's a working mother. Because of her schedule, she's not always available to accompany her children. She basically claims that they have to be inside at all times, that the neighbors are so restrictive, the rules are so restrictive that they can't do anything unless an adult is present. Could not even leave her children at the driving range to use the restroom due to overly restrictive rules. So she was physically there, but as she stepped away to use the restroom, she got fined or admonished or a notice was sent to her residence. And she just felt like she was being harassed. She wanted her children to be able to use all of their facilities, even if she wasn't available. There was one in here that kind of brought it home. So here were some of the rules. They specified diapered children must wear leak-proof swimwear. I think that's reasonable. An adult to accompany children under 12, that's fine. To me, I think that's just safety and public health. This one was the worst one, Mike. You see that? Children under 12 must be accompanied by an adult when riding a bicycle, walking on the course, fishing in the pond, or swimming in the Master Association pool. Not allowed to ride a bike, huh?
Wow.
That's not okay. I don't think it's okay. I'm not the judge. I'm not the jury. I don't get to decide this stuff.
You know, the fishing in the pond thing would seem like not a big deal, but with the gators we have, that you have to think about that a little bit.
You have to think about it. And so this is, this is still in court. We're still going to have to figure out exactly what happens with it. But I've had a couple of these come up where you have rules in place by, pretty restrictive associations. They, there aren't that many kids, and the kids they do have cause problems. You got to be careful. These rules are not allowed. I would assume some of these rules are unconstitutional. The association will have a problem. There will be a fine, I'm guessing. And I do see it, unless you are a 55 and older community, or that there's some sort of public health risk, like unsupervised children in the pool. You can't have rules that limit where they can walk or what bicycles they can ride if they're not supervised. There's a line. There's a line. We tend to forget that sometimes, but there is state law. There's fair housing rules. We can't discriminate based on age, sex, sexual orientation, all these race, all these things. We don't think about it all the time, but occasionally you'll have a client that's affected by this. So in this case, Mike sent this information to my buyer and gave him the case, told him what it was. He knew about it, but he didn't know the details. So we spent a few minutes on the phone just talking about it. And he said, well, it does seem pretty restrictive. I hope they get it figured out. And he goes, is this a huge risk to me, Christian? And I said, no, I don't think so. Hopefully it just makes the community a little better. They'll probably agree to some sort of modification of their rules, and the state of Florida will get out of the way. Maybe there will be a small fine, but it's not going to severely impact the association or the value of it going forward, at least in my opinion. Sound reasonable, Mike?
That's right around the corner from me. That actually kind of surprised me there.
I think you should have those rules at your house. No horses. All right, Mike, any other words of wisdom for the group?
No, I once again reiterate, all commissions are negotiable. You made that point. We made it our sales meeting today. We're getting ready for summer. We'll see what summer brings.
We'll see what summer brings. We're not only going to have listing agreements, but we're going to do buyer brokerage agreements. Don't be afraid of them. Just know your value, put what you want to charge, specify your duties. We're going to see all new forms, but getting familiar with the ones we have will be a huge value to you. So thank you, Mike. Thank you, everybody. Good luck today.
Happy Memorial Day.
Happy Memorial Day.